Hi, Mike Kaplan here from Kaplan Morrell. Today we're going to talk about final admissions of liability. Every workers' compensation case, I shouldn't say every, but the majority of workers' compensation cases, when the injured worker is placed at max medical improvement and either given an impairment rating between 0 and 100, the carrier files something that's called a final admission of liability. Now, this is a very critical time in the case, and I always tell people that when you're in the workers' compensation system, you got to look at it as it's like a minefield, and there are lots of mines that you can hit as an injured worker that can compromise your rights and your claim. The final admission of liability, when that gets filed, that results in all the mines in the system getting really, really close together, because that is the critical time where an injured worker absolutely needs to do something with that final admission of liability. And what it's called is you have to object to it. And you need to object to it within 30 days of when the final admission of liability is sent to you. So the insurance carrier has a duty to send the final admission of liability to the injured worker or their attorney if they're represented. And within 30 days of the final admission of liability's date of service, which is located on the last third of the page, of the front page of the final admission, if you fail to object within those 30 days, then the injured worker's case is closed as a matter of law and only is subject to being reopened. Well, being reopened is it can be very difficult to reopen a workers' compensation case. So for all intents and purposes, if you don't object to that final admission of liability timely, your case is pretty much closed. And there's a lot of things that need to happen to reopen it. So if I have had several potential clients come to me after a final admission has been issued and 30 days has passed, and I tell them, look, there's very little that I can do at this juncture in time unless your condition has worsened, and I can prove that, which can be timely and very expensive. So for all you injured workers out there, when you get a final admission of liability, you need to pay attention to that. Many people get lots and lots of things from the insurance carrier and never even open up the envelopes. That is a critical mistake, because there are certain things like a final admission of liability that can be sent to you that if you don't do something with them, you're in trouble. So one of the main things that I do, and what my partner and my associates do for our clients, is we make sure that we object to those final admission of liability. In fact, if I missed an objection to a final admission of liability, then honestly I open up myself to being sued for malpractice, and thankfully that doesn't happen. So that being said, all you injured workers out there, remember, when you receive a final admission of liability, you must do something with that. And like I said, the mines are getting closer. You can hit a major one by not objecting to the final admission of liability. And I advise everybody, understand your rights, understand and be educated in the system so that you can make an educated decision of what would be best for you, whether you hire an attorney or not. Of course, at Kaplan Morrell, you can call us and we can educate you. 303-780-7329 is the Denver office number, and we're also located in Greeley. So again, Kaplan Morrell Nation, I hope that's helpful. If you have any questions about final admissions liability, please give us a call.